Good morning and welcome to the SF 1750 webinar series from the HOA Leadership Network and SJJ Law. We're so glad that you could join us this morning. My name is Mark Foster, and I am your facilitator for today. So we're glad to have you, and we've got about an hour's worth of conversation here that will dive into the covenant enforcement of the new law. Joining me today is a partner with SJJ Law, one of our fine sponsors of the HOA Leadership Network, Aaron Brooksby. He's an attorney, an HOA attorney. Many of you who are members of our network who've been to our chapter meetings have probably seen Aaron. Aaron, good morning.
Morning, Mark. Glad to be here.
And we are very happy to have you. This session is being recorded and will be available for playback. As I mentioned, this is a 1 hour presentation today. The slides of this presentation are already available in PDF form on the HOA Leadership Network Resource Hub. You do need to be a member in order to access the Resource Hub. If you are, for some reason, not a member of our network, you can join for free and access the Resource Hub to download the slides. The questions that we will take today will not be verbal. We ask you only to use the chat function in the Zoom chat feature. We ask you to please limit your question to the current topic only, just so we can stay on task. And then please keep your microphone on mute if you would, so that we can continue unabated here. So we do have a good program for you this morning. As I mentioned, this is the first part of 3 parts that we are offering today, and actually over the course of 3 months. So our first part today is on covenant enforcement. We'll be covering rules, fines, due process, collections, parking. Aaron, I know you're ready for that one. That seems to be a popular item.
It is.
Architectural approval, grievance rights, and legal fee notice and retaliation. So those will all be covered by Aaron today. We do have 2 more scheduled. There's one on August 26th at 9 a.m. where we'll get into governance issues related to the association and how you should be managing your board meetings, working sessions, conflicts of interest, the safe at home procedure, and how that may affect our board meetings and disclosures. And then on September the 30th, we'll get into contracts. As many of you know, our contract management will change with this new law. So we'll be covering that as well. And we'll have a checklist for you on how to get your board ready for the upcoming legislation, which goes into effect on January the 1st. So today, once again, we're covering covenant enforcement, part 1 of our series. This, of course, has a history behind it. It's not just a 1-year thing. This has actually been bubbling for 2 legislative sessions. So, Aaron, I'll turn it over to you just to provide everybody listening today a little bit of a history on SF 1750.
Yeah, sure thing. So, just to make sure everybody's on the same page, we've been talking about this for 2 years now. But back in 2024 is when it actually started. The legislature approved a working group to investigate HOAs. They provided some recommendations to the legislature at the end of 2024, and then they started drafting that legislation in 2025. That was a big surprise to most of us in the industry. I don't think they did a very good job at actually taking the advice of the recommendations from the working group. They kind of implemented a lot of things that weren't necessarily helpful, in my opinion. But SF 1750 is what came from, or that's where SF 1750 came from. In 2025, it passed it on the Senate floor. It didn't make it out of committee in the House. And so this year they brought it back and they did a series of like delete all and replace amendments. And so it has a lot of the same characteristics from last year, but ultimately it did get changed quite a bit to make it so it's not a complete disaster. It still has some funkiness to it that doesn't really make a lot of sense in some situations, but ultimately it's workable. And now that we've had 2 or 3 months to kind of chew on it for a while, many of us in the industry are starting to understand what it actually means. So in 2026, it passed the House, it passed the Senate, Governor Walz signed it, and it went into, well, it became a law. There were a couple of sections that went into effect immediately, and that was just the definitions. And so now it defines some helpful terms like property manager, what is a property manager, and things like that. But just the definitions went into effect essentially immediately. Everything else, all the substantive things, everything we're going to talk about today, all of that goes into effect January 1st of 2027. And so you can prepare for it. You can adopt policies before January 1st, 2027, certainly, if you want to prepare for it. But ultimately, there's no consequences if you're not following this stuff until January 1st. So with that, let's go ahead and move in and kind of dive in a little bit, right?
Right. Thanks, Aaron. A good history lesson, and we will get started on covenant enforcement. So we'll spend a couple of minutes on several sections here. We will be pausing so that we can catch up on any questions. Just as a reminder to participants, please use your chat function only. This is not a verbal interactive session. Use your chat function, please, to provide us with any questions. We'll be monitoring the chat box. And when we get to the point where we pause and can take those questions, we'll do so at the end of each section. Aaron, go ahead.
All right. So I like to kind of preface before I guess we're going to dive in pretty deep, and that's the goal of these webinars, is to actually, instead of just providing something high level, we're trying to give you better information. The goal when we dive into each one of these little sections is kind of trying to understand, I guess the part that's been helpful for me is to understand what the legislature was trying to do. Now, whether or not they actually did that is well, I guess we'll see. And oftentimes I don't think they did. But the goal was they pitched this as a consumer protection bill to protect homeowners in HOAs. Because they feel like there's not a lot of protection for homeowners. I may or may not disagree with that, but that's how they pitched it. And so as we review each of these sections, that's kind of the idea behind a lot of this stuff. So the first one here, the very first line of this. So each of these slides, you have the summary at the top, down the left-hand side, I guess the left-hand side, you have the highlights in those bullet points, and then we have an actual screenshot or a clip of the actual text of the statute. And so when we're talking about rules, this is what the new law will include. And this one I think is kind of a funny one. Rules and regulations that are adopted by an association must be reasonable. That's the law. I think that one is kind of funny because I think that was the standard previously. I don't think a board could adopt an unreasonable rule or a rule that they didn't have authority to adopt. But now you have to adopt only reasonable rules. It's the law. The change here, besides them, the law didn't say they had to be reasonable before. Now it says they have to be reasonable. I don't think that changes anything practically. The change here that will be a major change is that you have to provide your homeowners a 21-day notice and comment period prior to adopting new rules. As I think best practice currently, pretty much every single board of directors has the authority and discretion to adopt and implement new rules and regulations essentially on a whim. As long as you're following your corporate formalities for proper board approval, you can adopt new rules today. Best practice once you adopt new rules is to send those out to the community and give homeowners around 30 days notice prior to enforcing those new rules. So that's been best practice, and that's what most associations and community managers follow. The change here is that before you adopt that new rule, you have to give the homeowners 21 days notice. And at the meeting where you're going to adopt those new rules, you have to provide an opportunity for homeowners to comment on those new rules. I think it's probably still best practice to provide a time period after that 21 days before you start enforcing. But now that we're giving homeowners 21 days beforehand, it might be reasonable to reduce the 30 days after they're approved to 21 days or a little shorter, depending on the rule. So anyway, essentially all this is doing is it's providing homeowners notice before boards adopt rules, and then essentially extending the period. So if this were in effect today, your board couldn't adopt a new rule today. You would have to provide notice to your homeowners, and the earliest we could do it is essentially the end of August. So it just kind of delays things a little bit. A little frustrating, but not unworkable. Let's move to the next one. Um, Relatedly, we're talking about fines. So the big thing here that the legislature pitched is that they were going to limit fines for HOAs to $100 maximum fine. And that's kind of what this does. It's actually, I would argue that's not what this does. Um, it does place some restrictions on fines, and the takeaway here is you have a $100 maximum fine for a first violation, but then there's a list of exemptions. Um, so the $100 fine cap doesn't apply in three specific scenarios. So if there's an immediate impact on the community or the health and safety, you can I guess levy a greater than $100 fine. If it's going to cause physical damage to the unit or another unit or the common elements or a limited common element, again, it can be more than $100. And then the third one that I think is the most important is if the homeowner is going to get some financial benefit from breaking the rules, you can implement more than $100 fine. That's the big one that like I brought it up in the first hearing I went to in 2025 that what if somebody's leasing their unit and they're not allowed to lease and they're doing it on Airbnb and they're getting $1,000 a night? If we're limited to the fines that we can implement, they're just going to wrap that into their business expense and continue leasing. So here, one of the exemptions specifically addresses that and says, if somebody's making money off of the violation, you can increase the fines more than $100. And then the last caveat to this is reading the text here carefully. It specifically addresses initial fines, and it's not $100 for one violation forever. It's $100 per violation. So if somebody is violating the governing documents every day, that could be up to $100 every single day. And so I don't think it's as much protection as what the legislature intended, but this is how they wrote it. And so ultimately, I don't think this is a major change. Best practice today, most fines are $25 to maybe $50 for a first violation. And so I would tend to say, don't give this one too much thought because I don't want your first fines to immediately all go up to $100 because I don't think that's good practice for the industry or for your associations. But that's fines. So next one we're going to go to, again, a lot of this stuff I would argue was best practice. So if you've been professionally managed or if you've been really connected with the HOA leadership network, you probably have been doing these things. But now, like I said right at the beginning, now it's the law. Now you have to. And so that's kind of the funny part for me. This one here, you have to have a schedule, a fining schedule. Previously, it's been best practice to have some form of a policy that lays out how you implement fines, what those fines might look like, things like that. Now, the legislature specifically said you must adopt a policy that relates to the imposition of fines. And that has to have, it doesn't have to be a full list of every single fine you could ever think of. It's just the common ones, mostly as an example. So like, I'm throwing these out there. These are hypothetical, but they're pretty common. So like pet waste violations. If you're not picking up your dog waste, that's a pretty common fine. If you leave your garbage can out, that's a pretty common fine. If you're releasing your unit and you have a rental cap or a prohibition on leasing, that's a pretty common fine. Those types of common fines, you have to list those out and list the amount of the fine. The big thing that's different here that frankly I might be a little overkill than what is needed, but the big thing that is required now by the statute is you have to create a description of how to remedy those fines. frankly, let's go to the dog waste one. If you get a fine from your HOA um, about you have a bunch of dog waste in your front yard, it's pretty clear that to not get another fine, you need to go pick up the dog waste. But the legislature specifically said you have to include that remedy in your fining policy. So it's a little basic and obvious, but that's one of the requirements now. And so this will be a new, probably everybody will need to update their fining policy because I would be surprised if anybody had everything they needed here already. But we're all working on that, and if you need help with that, happy to help out. But that's the fining schedule. You have to have a fining schedule now instead of it being best practice. Due process. So this one, it's a little bit of a change. They've made some tweaks in recent years relating to HOA covenant enforcement and due process already. And so I think it's been about 2 years. And so we're all kind of up to speed on if you implement a fine, you have to provide your homeowner an opportunity to appeal that fine, period. If it's a fine, they get to appeal it, or they have an opportunity to appeal it. If right now, if it's just a friendly reminder, or if you're sending a violation notice without a fine, they don't have an opportunity to appeal it. Under this new law, it doesn't matter what you're sending, if it's a fine or if it's a friendly reminder with no fine, or if it's a violation without a fine, that homeowner has a right to appeal it. That's the main change here. The other thing, most of the time, currently, we give homeowners about 10 days to request an appeal before we implement the fine. The change on this one is that the homeowner now specifically has 30 days to appeal. So again, it just kind of extends the timeline a little bit. That's the protection that the legislature was going for here. The one other big change, and it's the last bullet point on this slide, if a fine is upheld, so if you hold a hearing or an appeal and the homeowner shows up and explains why they thought they're justified in violating the rule, and the board says, I think that's bogus, or that's not a very good reason, and you implement the fine, you have to provide written notice to the homeowner that the fine will be upheld, and you have to explain your reasoning. So that's a new change that frankly I think is probably good. If you can't explain your reasoning for why you're continuing to fine that homeowner after they've explained why they shouldn't be fined, it's probably because it's for an illegal or improper purpose. And so now you just have to tell the homeowner, we're fining you and we're going to continue to fine you because this is our reasoning. So that's what has to be included once you fine somebody and you uphold a fine after an appeal. I think we want to pause here, and there's been a bunch of questions that came through.
Yes, Aaron, thanks for that great overview of that first section. So we are going to pause here and catch up on a few questions that have come through. One isn't specifically related to fines, but comes up a lot is, and we hear this in our chapter meetings, does this amendment to MCIWA, the Minnesota Common Interest Ownership Act of 1994, if there is an HOA that is not yet part of MCIWA because they were built prior to that time, does any of this affect them? And what advice do you have for them if they are pre-MCIWA properties?
Yeah, that's a pretty common question that I've been getting too. As I said, there was a lot of delete and replace amendments to this, to SF 1750, and the applicability section changed a little bit with every single one of those. And so I don't have a specific answer of do these changes apply to us if we're non-MCIWA. There might be some of these things that do apply to non-MCIWA associations, because even if you're a pre-94 townhome or you're a 515, not a 515A, but a 515 community condominium, or you just never opted into MCIWA, there's still sections of MCIWA that apply to all common interest communities in Minnesota. And unfortunately, I don't have it right off the top of my head of which specific sections apply to non-MCIWA associations. If you are a non-MCIWA association, I would reach out to your attorney and get a legal opinion on what parts of these changes apply. That probably will be something that we at SJJ compile in the coming months, but we're still trying to chew our way through the actual text to figure out what the legislature actually did. And we're getting to the point where we're going to know exactly how it applies to MKIWA and non-MKIWA associations, but we're just not there yet.
Sure. So more to come on that as any new law comes into effect. There's always some ambiguity. This one seems to have large ambiguity, but we're glad that you guys are going to be at SJJ Law looking into that. Another question from one of our viewers today: if your declaration allows for recouping damage from an owner, is that different than a fine, in your opinion?
In my opinion, that's completely different. Most of the time, most MKIWA associations have the authority to assess back costs that benefit less than all of the units to just the units that benefit. I consider that, and I define that as a limited assessment. It's not a fine. I'm not fining a homeowner because we're doing work to your deck and it's just your deck. That's not a fine or a violation. It's just work that only applies to you. Similarly, as this question asked, if I damaged the property, if I did this when I lived in a townhome, I put my barbecue grill away before it was cooled off and it melted the vinyl siding, and so I paid to replace that siding. I didn't do it, but the association assessed it back to me, and I paid for it. And so just like that, just the damage to the property, that's not a fine. Technically, the association, you might make an argument that if it's egregious enough, it constitutes a fine, but the actual damage, the replacement cost, I wouldn't consider that a fine, and that won't apply. The fining requirements and restrictions don't apply to damage.
Okay, great. Another question we have received about the $100 maximum fine. So, if your governing documents specify that you would charge a $50 fine for a first violation and that you can continue to maybe raise that fine over the course of multiple violations, does it mean that we need to cap the final fine at $100 for multiple violations from the same owner?
It does not. So I'll read you. I have it on another screen right here, so I can read it. The association may impose a fine greater than $100 for a subsequent violation for the same conduct. So it's really only talking about an initial fine. So if you have an escalating fining structure where initial friendly reminder, hey, FYI, you need to fix this, and then they don't, and it's $25, and then it's $50, and then it's $100, and then it's $150. That's completely fine and authorized under the law.
Interesting. Now, another one we get often here, Aaron, and one came through from one of our viewers, is that if a resident has received a fine or multiple fines and has not paid the fine, what can the board do? Can they assess a fine on top of that fine for not paying? How does that work?
We're gonna get into that in our next section that talks about collections, and
Okay,
I'd rather rely on the slides than just answer it outright. So
that sounds
let's
good.
skip that one and move to the next question, or we can just move to the next slides.
Yeah, I think again, we're trying to take the most relevant questions here for the topic. So, a reminder to those who have joined a little bit late, please use the chat function for your questions only. This is not a verbal interactive session. So, we would appreciate using the chat function, and we will pause at the end of each major section. So, let's get into collections and the collection policy, Aaron.
Okay. So, again, this is just like the first slide on the last section. You have to have a collections policy now. It's been best practice to have a collections policy for years. And I'm kind of surprised if you're an association that still doesn't have one. But now, beginning January 1st, it is the law. So if you don't have one, you're going to be in trouble, even though there's no MKIWA police. Your homeowners can get you in trouble, I guess. But I don't know who they're going to tell. Either way, you need a collections policy. It's been the best practice for years. Everybody, I would argue, even if this law didn't exist, you need a collections policy. It protects the board, it protects your homeowners, protects the association, and it's good governance. So it has to be a formal policy. That's all this slide is saying. let's move to the next one. This is, I think here is where we're going to touch on the question that we just had. So here we're talking about interest on past due assessments and then late fees. So right now, again, I think all of this is mostly best practice, and they're just saying now it's the law instead of best practice, specifically as it relates to interest. The law starting January 1st, 2027, if you implement interest on past due assessments, it can't be more than 8%. That's it. Okay. So you can't do 10%, you can't do 12%. I would argue that if you had a 12% applicability in your governing documents already, that might be unenforceable currently. It certainly will be unenforceable starting in January. The second part of this is that an association, you can impose a fee for a late payment of common expenses and special assessments not to exceed the greater of $20 or 5% of the amount owed. So this answers that question we just had. You can't impose a late fee for a lack of payment of a fine. So if I get a violation and a fine and I don't pay it, you can't throw a late fee on top of that and double it up and continue to increase that just on fines. You can only implement fines, or you can only implement late fees on past due assessments. Whether it's a special assessment, an annual assessment, your regular monthly dues, whatever you want to call it. If it's what you're regularly paying, you can add late fees. If it's a fine, no late fees. The money here is, or the amount here is an interesting one. The way the legislature pitched it, they said it's a $20 maximum late fee. And a lot of us said, that's not very much, and might not be an incentive to actually pay on time. So they adjusted it, and now it kind of turned it into who knows, and essentially created an unlimited class where it needs to be 5% of the past due amount. Now, I'm an attorney. I have some accounts my firm has lots of accounts in collections. Apparently, there's a lot of people in Minnesota that don't pay their dues. And I'm working a couple that I've worked for the last 3 years that we're trying to collect on. And these people haven't paid their dues in 6 years. And the amounts are in the $8,000 to $12,000 range. And so technically, the way this law applies, I could implement a 5% late fee on $12,000, which is way more than $20. So I think the trigger, or kind of the I don't know what I would call it. If your dues are more than about $420, you're not limited to a $20 late fee. That's the reality, because 5% of $420 is more than $20. That's what that math comes out to be. So if you have dues less than $420 a month, then you're going to need to have a $20 max on your late fees. If you have more than $420 a month dues, you might be able to increase those late fees accordingly. Again, most of this is have a collections policy, spell this out ahead of time, and do it the same for everybody. Don't try and say, oh, this guy hasn't paid in forever, we're going to do 5% on his, but everybody else is going to get a $25 late fee. Don't do that. That'll get you in trouble. But yeah, that's kind of the updates to interest and late fees. Late fees is not exactly what they said it would be, but it's workable. So let's move to the next one. As we're dealing with collections, I guess this was a problem. Frankly, I don't really know what changed, but ultimately, what this section says is if someone is trying to make a payment on their past due assessments or on their fines, and they have $1,000 past due and they only have $500 this month and they're trying to pay, you can't tell them, no, we're not accepting your $500 payment. We have to receive payment in full. So that's not allowed anymore. You have to accept payment, even if it's not payment in full, unless foreclosure has been commenced. That's the terms they use. And that's going to be more on the attorney that is doing the foreclosure and collection. If it hasn't been turned over to your attorney or if you're using a collections agency, if it hasn't been turned over yet, you have to receive payment. You can't tell people they can't pay, even if it's not payment in full. So that's the big thing here. I think that's fine. I would argue that's probably, for most reasons, that was probably best practice already. But if it makes it a little frustrating if that wasn't your current practice, but again, not unworkable. You need the money coming in, and so essentially the legislature said you have to receive the money when they want to pay it. Let's move to the next one. This one also applies to payments. This one is kind of an upset, and if you're professionally managed, or even if you use like a finance only management company, this is going to be a change that you probably won't notice. If you're doing all the finances yourself, this is a major change you need to pay attention to. From my understanding of most of my clients and most people I talk to in the industry, the best practice currently and has been for years is if we get a payment, if a homeowner sends in a check and they're in arrears, or if they have a past due balance, we're going to apply that payment, regardless of what it says on the little memo line. We're going to apply it to the oldest debt or the oldest amount. So even if you wrote in here, it says, I want to pay August 2026 dues. If I haven't paid since January, the best practice and the most common practice that I have heard about is we're going to apply that amount to January, and you're going to still be past due through August. And it doesn't matter what's on your account. If you have fines from a long time ago and you send in a check and those are the oldest amounts, those fines are going to get paid and you're not going to have paid your dues. What this law will say is you can't do that anymore. You have to apply payments to common expenses and special assessments first. And you can't kind of cherry pick and say, well, you've had this fine that's been outstanding for 2 years and you sent in a payment. We're going to apply your payment to the fine and you're going to have a past due balance on this month's assessment. That's not allowed. It's a different system of accounting. And if you are doing your own finances, you should look very closely at this language and probably get either work with a CPA or an accountant or an attorney and figure out what you need to do to change. I know all of the management companies in the state have looked very closely at this and they're updating their software and all of their procedures to account for this. It is I would say, a big change. It also means that we can't just rely on people continuing to pay their dues to enforce fines. So if a person really doesn't want to pay their fines and they are just up to date perfectly on their dues and they never overpay, those fines will sit on their ledger for years and years. And we have to use other remedies to collect those fines. So it kind of limits a board's authority or the teeth of a fine a little bit. But it's one of the major changes here. Let's move to the next one and talk about payment plans. This one's an interesting one. Again, I would say this was best practice. Now it's the law. An association must consider offering a reasonable payment plan for a delinquency. So if you got a homeowner who's in collections or that has a past due balance and they say, hey, I can't pay it all right now. Can I pay $500 a month until it's good to go? The board must consider that. If it's unreasonable, you don't have to accept it, but you do need to consider it. And so you can't have a policy that just says, we don't accept payment plans. That's now going to be illegal under this law. You have to consider payment plans and you have to make a decision on whether or not the proposed payment plan is reasonable. And so probably you want to include what a reasonable payment plan looks like in your collections policy. I would argue that a reasonable payment plan is any payment amount that gets it paid within 12 months. Because frankly, even if you send it to collections and you go to foreclosure, it's going to take about a year before you get your money anyway. And so let's just have them pay it voluntarily instead of wielding this big stick over their head of foreclosure. But that's the change here is you have to consider a payment plan. You can still say no to it if it's unreasonable, but the best practice here is document that. Put it in your collections policy, and then as you're receiving those, document it either in an official notice to your homeowner and say, hey, we received your request for a payment plan. We don't think it's reasonable. It's denied. make that documentation in writing, you'll be protected. Let's move on. I just mentioned foreclosures, so we're going to talk a little bit more about foreclosures here. A lot of this you don't really need to know. I would be shocked if any of you are actually doing any foreclosures on your own, and I would say you shouldn't be doing that. That is work for an attorney. Even if you're an attorney and you're serving on your board, you shouldn't be doing that. So the change here, I would argue this is a nothing burger, as we call it. All this says is you can't initiate foreclosure unless a homeowner is more than 3 months past due. That's it. And frankly, as an attorney who does foreclose on or initiate foreclosures, I'm never going to initiate foreclosure prior to 3 months past due, because most collections policies, you're going to give your homeowners a 30-day past due notice, a 60-day past due notice, a 90-day past due notice, and then you're going to send it to an attorney. And so that's the best practice for collections policies is you're going to wait about 3 months before you even send it to an attorney. So that's the reality here, is that the legislature was trying to say, hey, look, we're protecting everybody by prohibiting this. Even as an attorney, even if your collections policy was a 30-day refer to an attorney, I have federal regulations that prohibit me from initiating foreclosure without trying to contact the homeowner and giving the homeowner like 35 days to dispute it beforehand. And so this doesn't do anything. And it's more of a concern for the lawyers that are doing this to ensure that the timelines are correct. It's not something that the board really ever needs to worry about. The other parts of this, yeah, we can skip. The last point I'll say on that is there's other steps an attorney has to take that are different from a standard foreclosure if they're foreclosing on an association's assessment lien. So there's notices and letters that we send to homeowners and tenants, and now we have to send them via certified mail instead of non-certified. But I think the requirement is we send it certified and non-certified. And so there's just additional requirements for those actual actors that are foreclosing. So me as an attorney, I have to know about this. You as homeowners and board members, don't worry about it. If we're doing it wrong, we will be liable for it, not you as a board. All right, that's all I had.
Good. Yeah. Thanks, Aaron, on that section and the nothing burger section, as you call it. So let's catch up on a few questions related to this. We got quite a few coming in from viewers. First of all, should a policy be written by an attorney? And if so, is it tax deductible?
I'm hold off on that second part of that question because I need to think about that. The first part, does an attorney need to review our collections policy or any of our policies? As a blanket statement, I would say generally yes. It's a good idea to have an attorney review any policy the board adopts to ensure that it complies with your requirements, complies with your corporate formalities, is enforceable, and specifically as it relates to this stuff, because it's all new, it's a good idea to have an attorney review it just to ensure that it's actually doing what the law requires. Especially in these first couple of years of this new law, we're still kind of figuring it out and it's not common practice yet. And so it's a good idea too. The 1.5 of that I will say is I know that most of the, if not all of the property management companies in the state are all aware of this. And I'm pretty sure that they're all putting in place a lot of changes in their policies, their internal policies, and they will be providing opportunities for the boards to update those policies that have likely been reviewed by an attorney. Now, if you don't trust your management company, that's another issue. But if you don't trust your management company, you can certainly have an attorney review it in addition to the management company reviewing it. Frankly, your management company are not attorneys. And so even when it's drafted by a management company, the management company probably had the template reviewed by an attorney or drafted by an attorney. But once it's applied to you, depending on your level of comfortability with risk, getting an attorney to review it, it's good practice. It's usually pretty cheap for a quick review. And sometimes if it's like something that my office drafted and sold to your management company, and then I take a look at it, I might not even charge you for that because it's like, oh yeah, this is mine. I think it's good.
Sure.
The second part of that question, I'm not going to answer because, frankly, I'm not a tax attorney and I don't know that off the top of my head if it's deductible.
About the tax deductibility. Okay, fair
Yeah.
enough. So we do get questions about the fact that this law is going into effect on January the 1st. So what happens in a scenario where a collection process has started in, let's say, November of this year? So that's prior to the implementation. Does any of this apply? Now, you've largely answered that this is best practice, but how does it impact any sort of procedure that has started prior to the implementation of this bill?
That's a great question. And this type of changes to foreclosure and collection happens, I would say, regularly, at least every other year. Maybe not every other year, but every 4 years or so, we get some changes. And so that's a question that we've had to answer a handful of times already, even in my practice. Um, and there's specific wording we look for in the statute. In this one, the SF 1750 has a couple of trigger words that say once foreclosure has been commenced. And so as an attorney, like they don't define what commenced means, but as an attorney, I can reasonably argue that foreclosure commences once I record a notice of pendency and power of attorney. That's like the public notice that gets recorded with the county that says, hey, look, this person's getting foreclosed on. It doesn't mean when I schedule a sheriff's sale. I can go deeper into that, but I don't need to. The reality is probably it won't impact anything that is already set up for foreclosure until after January 1st. So frankly, I've had the last time the big law changed, we had a really messy collection account that we all knew was messy. And frankly, it was a homeowner that was just disagreeing with the reality of what she had to pay. She ended up suing the association, so it didn't really matter. But we initiated the foreclosure prior to the start of the January 1st, and we initiated foreclosure on like December 20th, just so that we could preclude any of those changes. And that's a strategic choice that is an option because we know this is going to happen. So if you have past due accounts that you're kind of sitting on, hoping that the homeowner will pay, maybe it's not a good idea to sit on those. Send those over to your attorney, get those initiated this year, and then you don't even have to worry about half of this stuff.
All right, we have about 15 minutes left, but I want to get to one other question that seems to be coming up quite a bit. So the whole issue of the $20 or 5%, does that apply to a monthly past due? Does it apply to the total balance? How does that $20 or 5% get applied, Aaron?
That is a great area. We will find out. But what it says, and I'll read it for you right here. A late fee cannot exceed the greater of $20 or 5% of the amount owed. I can make arguments on both sides of that to say, well, no, the amount owed is the new amount owed. But that's not what the statute says. It doesn't say the new amount owed. And so another argument on the other side is to say of the total amount owed. I think the total amount owed is probably the more weighty argument here. And so technically, I think you could say if you could have theoretically, I don't think this is the right way to go about it, but theoretically, you could have an escalating fine late fee schedule. If you have somebody who's 6 months past due, you could implement a higher late fee. Now, whether or not that's a good idea, that's a different question. But theoretically, those types of escalating late fee schedules are available now, where prior to this, I would have argued you shouldn't really do that. So the short answer is we'll see, because eventually somebody's going to sue, and then the judge is going to have to interpret this, and we'll see what how a judge is interpreted. Right now, it's just up to my interpretation as an attorney, and I can make arguments kind of all over the place because it's not very clear.
Right. Well, as we say, the plot will continue to thicken. Well, let's move on to our next sections, given that we've got about 13 minutes remaining. Let's talk about our favorite topic, parking, Aaron.
Yeah. So this one is probably the section, besides the late fees, this is the section I've received more questions about than any other new change. And to be fair, there are some nuances here, but I want to simplify it. There's 2 points to this. The first one is an association cannot enforce parking rules on public streets. That's what I would argue that's what it's been for years and years. The association doesn't have authority to enforce rules and regulations that are off of the association's property. So that's the first part of this. It's now the law. You can't. You didn't have authority to before, but now it's illegal if you do. So setting that part aside, the reality here is the goal of this is to allow homeowners to use the parking space that they paid for when they purchased their house. So most of this applies to townhomes or townhome style setups, or situations where you have a garage and a driveway and then the house somewhere. And lots of associations, even some of my clients are very stringent and say, we don't want people parking in the driveways. We want people to park in their garages so that it looks nice and fancy, like no one's ever home. This new law is saying you can't do that. People paid for a driveway. If they have a driveway that's built as a parking space for that unit, you can't tell people they can't park there. There's some nuance to this. That doesn't apply if there's physically not enough space. So I work with the one that I remember the most. If you could imagine a 90-degree parking space. So there's a driveway here and a driveway here. And then there's garages on the insides. But there's really not enough space to be able to park a car here and park a car here and have them both be able to back out. And so if you have a situation like that where it's physically or geographically impossible to get two cars parked, you can still prohibit parking in those driveways and require parking in the garages. The other things that lots of associations have, I have a client who has been fighting with a homeowner that drives, it's one of these like Amazon, the mini Amazon trucks. It's not an Amazon truck, it's a plumbing van, like a mini van that has a big plunger on it, and it's like wrapped in blue water, and it's a plumbing guy. Everybody knows this guy's a plumber because he drives this car to work every day and he parks it in his driveway, and the association hates it. It's parked right next to the really fancy sign as you come into the property, and everybody wants this, at least everybody on the board wants this to be parked either off-site or in the garage. This statute specifically applies to work vehicles. If it's a work vehicle that you use that you don't need a CDL for, so that the CDL requirements in Minnesota is if it's over 26,000 pounds, you have to have a separate a CDL, a driver's license for heavy vehicles. If it's less than 26,000 pounds, homeowners get to park it in their driveway. Kind of period. That doesn't apply to RVs. It doesn't apply to recreational vehicles, trailers, boats. You can still prohibit those. But if it's their regular car, you can't just say, sorry, you can't use your driveway that you paid for. Even if you own it, or even if the association owns it. This doesn't apply to guest parking spaces, but it only applies to like the situation where a homeowner buys a house, it has a garage, and there's a driveway in front of the garage. Doesn't matter who owns the driveway, they get to park there because that's the assigned parking space for their unit. There's always questions about this because there's some fact-specific questions. There are some exemptions. And so if you have specific questions about your situation in parking, it's a good idea to get a legal opinion to see what you can and cannot enforce because it's very fact-specific. Let's go on to the next one. This one, most of the rest of these are, I'm going to call them nothing burgers again. This one here, it's architectural review. All it says is an association must have an architectural review policy that if before a homeowner makes changes to their property. You can't just say we have this policy. You actually have to have a policy. This one is even more of a nothing burger. It's been best practice forever. Again, it's the law now, you have to. But again, I don't know of any associations that don't have a formal policy or something written into their declaration that spells out the policy. And so I don't think this is really going to impact anybody. The only thing here is that most best practice has been, and most common policy is if a homeowner submits an architectural review request or an architectural change request and the board doesn't review it within 2 months, it's automatically approved. The change here is that that extends to 90 days. So even if your declaration says it's automatically terminated or denied after 60 days or something like that, here there's an argument to say, well, you'd never responded, and so it's been 3 months. It was approved. So that's something to take a look at if you're concerned with that. But again, mostly a nothing burger because most associations already have this. This next one I could talk about for a really long time, but I'm not going to because we don't know what it means. This says that homeowners have a right to bring a grievance before the board or a committee appointed by the board to air their grievances, either orally or in writing. Don't really know what this means. I don't know what a grievance is. They don't define what a grievance is. The only thing I can really assume this means is that one homeowner or those couple of homeowners in your community that want to complain, they now have to be given the right to complain. You can't just say, "Hey, we're ignoring you. Sorry, you just complain about everything. We're not gonna hear it." You have to hear it now, or somebody appointed by the board has to hear it. If you can't resolve that grievance, you also have a duty to act in good faith to try and resolve it. If you can't resolve it, you have to notify or refer that homeowner to the ombudsperson. There isn't one right now, and they're super backed up, but that's what the law says. You have to say, "Hey, here's the ombudsperson. Go talk to them. Go try to talk to them." This one probably has a lot of questions. I don't know what it's going to look like, but we're gonna move on because it's a complete unknown. Um, this one's also kind of weird. It's not really weird. It's been best practice. Essentially, if a homeowner reaches out and says, "Hey, what does section 7.12 of our declaration mean?" Some associations, apparently, is what I've heard, some associations will turn around and turn that over to their attorney and say, "Can you give us a legal opinion on what section 7 says?" And the attorney gives them a legal opinion, and then they turn around and give that legal opinion or an interpretation of that opinion to the homeowner, and then the cost they also give to the homeowner. That's not how it works. That's not what you should be doing. And now it's going to be illegal if you do that. Essentially, before you do that, if a homeowner asks the board a question about some kind of interpretation of a governing document or something going on, you have to tell them, "Hey, we can answer that question, but we're going to get our attorney involved, and they charge X number of dollars per hour, and we expect it to cost X number of dollars for this. We're going to assess it back to you." Whether or not you want to do that, you have to provide notice before you do that. I think this is a pretty limited scenario, and I don't really want to talk about it anymore. Let's go to the next one. This is retaliation. Again, a nothing burger. Retaliation in HOAs, apparently the legislature thought is a common occurrence, and they say it's illegal, and it will be illegal. I think it has been illegal. It just wasn't stated that it was illegal under MCIWA. It stated that it's illegal under the Fair Housing Act and other human rights acts. You can't retaliate against homeowners. And they'll have another avenue of enforcing it if you do retaliate against homeowners. Don't retaliate against your homeowners, but certainly enforce the covenants equally against everybody. Let's move to the next one. Oh, that's it.
Yes, we got through that section. We do have a few questions, Aaron, relative to parking. So, and we've heard this in some of our chapter meetings. If we have a property in our HOA that has, say, multiple vehicles parked in the driveway, or vehicles that are unsightly, rusted vehicles, is there anything we can do about that with the new legislation? And the second part of the question is, if tabs are not current on the vehicle, can the HOA board do anything about that?
These are a little more nuanced, and I will tell you that this law doesn't address either of those questions, which defaults to what I would say even now. Unsightly vehicles is, I would argue, a pretty undefined term. Like, we live in Minnesota, and so most trucks have unsightly rust, even if it's only 5 years old. So that's a subjective standard that is hard to enforce and sometimes risky to enforce. And so I wouldn't necessarily talk about unsightly. And I think, to be fair, the statute, I point over here because I have another monitor that has the statute on it. The statute says that if this is a homeowner's let's call it a daily driver or their regular vehicle, they get to park it in their driveway. So what it doesn't talk about though is like broken down vehicles or project vehicles or stored vehicles. You can still prohibit storage of vehicles, I think, or at least there's an argument to that. I think you can also very easily prohibit non-functional vehicles from parking in your driveway. The unsightly ones, that's a little harder of a standard. But if there's a car that's on jack stands or has a wheel off or has flat tires and it's been there forever, or it's been there for more than a week, I think that's probably in the realm of enforcement, but not for you're not allowed to park in your driveway. You're not allowed to have a broken vehicle in your driveway. And so it's just kind of a different avenue we're going to pursue. Again, that's why I say parking is one of the biggest questions. A lot of it is very fact specific, and to be fair, is still nuanced, even though they put some boundaries in place.
Sure. And to be fair, Aaron, if an HOA has a private street or private streets, plural, then it is still up to the board of directors to be able to apply enforcement on those streets.
Correct. But you still can prohibit people from parking there. You can still implement fines, do everything you want to on private property. And that's why I say guest parking. You can still regulate, prohibit parking, tow, enforce fines, just like you can on a private street. The prohibition only applies to public streets and then to driveways.
Okay, got it. Very helpful. Well, that is almost the conclusion here of our first webinar. We have another one coming up on August the 26th. I'll show you a QR code here in just a moment where you can register. It's also available on our website at www.hoalnet.com. It'll be 9 o'clock on the 26th of August. We'll talk about association governance and how the running of your meetings, along with working sessions with your board, conflicts of interest, disclosure, and safe at home procedures will be altered. That's August 26th at 9 a.m. The RSVP on that is open. You will have to RSVP for that in order to get the Zoom link. We'll have a third webinar on September 30th at 9 a.m. to talk about contracts and have a checklist ready for you for readiness on the January 1st implementation. The QR code that's listed at the upper right-hand corner is scannable with your camera. That will take you to our RSVP Eventbrite. If you would rather, you can wait for a link in our Sunday e-blast if you're a member, or go to our website and you can see it there at the lower right-hand corner, HOALNET.com, and either join our network or RSVP. Aaron, thank you very much for being with us today. Appreciate it very much.
Happy to be here. Reach out if you have any questions. Happy to help.
Yep, happy to help. Aaron is there as a great resource, and Aaron will be appearing at our Maple Grove chapter in September. On behalf of the HOA Leadership Network and SJJ Law, my name is Mark Foster. Have a great HOA day.